Now we focus on the probe of a possible multi-million shillings fraud at the National Hospital Insurance Fund, NHIF. This morning, the NHIF Chief Executive Officer, Geoffrey Mwangi, and the Finance Director of the insurer, Wilbert Kurgat, appeared before a Nairobi court to answer to the charge of conspiracy to defeat justice, contrary to Section 117C of the Penal Code, and disobedience of lawful orders, contrary to Section 131 of the Penal Code. Now, Mwangi's lawyer, Professor Tom Ojenda, claims that the charge brought against the two suspects is defective. The top National Hospital Insurance Fund managers are under probe after a team of auditors sent to the institution claimed they had been threatened. The Ministry of Health had sent internal auditors to examine books at the insurance fund to enable it make decisions following complaints of graft. But the auditors returned to the ministry claiming they feared for their lives as they had been threatened. This is according to insiders at the ministry. As you can see, those are live proceedings from the Anti-Corruption Court, Milimani Law Court, specifically touching on this particular case of the possible multi-million shilling fraud at the National Hospital Insurance Fund. The two individuals, that is the Chief Executive Officer, Geoffrey Mwangi, and Finance Director Wilbert Kurgat, are in the docks. Let's just listen in to the live proceedings.
Your Honor, we have met that issue. If it were not so, Your Honor, I venture to submit that under Section 89, subsection 5, this court, suo motu, ought to have rejected the charge. But the charge has been admitted. Your Honor, are they suggesting, by any stretch of imagination, that this court does not understand the law? It has admitted a defective charge, or did not apply its mind at all to the charge? Your Honor, I heard you with respect to find that whatever the defense is engaging in can only fit one description: a dilatory tactic carefully calculated to water down the case that we have against the accused persons. And how will that be achieved? When the defense asks you to defer plea, they should be candid enough to tell you, defer plea to this date so that we can do ABC. And I'm glad they have disclosed what they intend to do. They intend to go and comply with the court order. I think until Friday, it had not occurred to them that court orders are important, must be respected, and no one has an option. Now that they are before you, this is what we understand them to be telling this court. Honorable Tobiko's orders do not matter. In fact, they did not matter at all to them.
And I wouldn't take the issue of Honorable Tobiko's matters do not matter. No, Honorable Tobiko, in that respect, you know.
Sorry, Your Honor?
When we say that Honorable Tobiko's orders,
yes, Your Honor.
I will take it to be the court's orders.
The court's orders, that's fine.
Yes,
that's fine.
yes. Yes.
Your Honor, to be fair, when your colleague has granted orders to the investigators, those orders must be given effect. It cannot be that the court on the one hand gives us orders, we seek to enforce them. If orders are disobeyed, we seek to bring those that violate those orders to justice, and then the court shuts the door. It has been submitted by my learned friends that they are not sure what book or books ought to be provided. You know, what happens to a party who is incapable or either want of knowledge or information to understand and interpret a court? He should come back to the court, seek an interpretation, and then comply. It cannot be for a party to say, I don't understand your orders, therefore I will not comply. That is impunity of the highest order. And what does the order say? You want to again, AKO 1